I want to bring in Mike Pezzullo now, former Home Affairs Secretary. Mike, thanks so much for your patience, and I know you were listening to that very carefully indeed. Let's start on the hate speech laws here, both the visa issue and the change in threshold. Tony Burke was asked for detail on what that new threshold would be, and he said he didn't want to get into that. And that was responding in terms of, would the river to the sea or globalise the intifada now be part of the new interpretation of what hate speech is? What were your observations?
Good afternoon, Laura. I thought it was a very comprehensive set of changes. In some cases, a long time coming, and I want to come back to that because these measures or ideas have not just fallen out of the clear sky as if they're ideas that have not been thought of, and I just want to make a comment about that in a moment. But in terms of specific phrases, of course, it goes without saying that you can't legislate through the Parliament, so much prescription that you're getting down to phrases. However, when the Parliament is presented with the explanatory memorandum and when it scrutinises this legislation in the committee stage, or if there's a quick, hopefully focused parliamentary inquiry to review the legislation, some of those case studies will have to be addressed, and the Parliament will have to think about, based on evidence from experts, whether such phrases will be captured. Because what you don't want to be in is in a situation later on where courts are subsequently trying to interpret what the Parliament's decided, and there's no material, either in the explanatory memorandum, in the second reading speech, or in the materials otherwise provided by the government to the Parliament in the form of the bill, or in any committee report that doesn't explain things like that. So I think this question about river to the sea, glorify the martyrs, globalise the intifada, if it isn't going to be confronted in the next few days, it certainly will be dealt with through the committees, through the Parliament's consideration of the legislation. But Laura, can I just make this fundamental point on the package? We're here on Thursday after this horrific, horrible, gut-wrenching attack. These measures could have been announced in the Prime Minister's courtyard or indeed anywhere else last Thursday, because the debate in quite specialised circles about thresholds, about whether groups are just pushing towards and nudging towards a legal threshold but not crossing, has been around for a long time. In fact, Mike Burgess, the Director-General of Security, just earlier this year drew attention to neo-Nazi groups and Hizbut Tahrir and others that understand what the thresholds are. There have been some in the community, Laura, who have been arguing for, and I'll give you one example very quickly, the Executive Council of Australian Jewry, and I've been sitting at the desk so I haven't had a chance to look at the document in detail, but if memory serves me correctly, something like this, a threshold redesign along these lines, was promoted by the Executive Council, I think, from memory in about November of last year. And why do I know that? Because I drew on that material, and others did, as we prepared our presentations to the Sky News anti-Semitism summit that you recall was held in February, led so admirably by your colleague Sharry Markson, as well as Alex Rivchin as well. So these are good initiatives. Don't get me wrong, I welcome them, but I really do want to raise the flag about why are we driving so hard on them, as we should be, 4 days after a tragedy when we've had a lead up where we could have attended to these matters.
Yeah, indeed, and there are people that have been calling for this, but there has been some resistance. What really, look, I accept the complexity here, but what I'm really not clear on today is where those thresholds will land, Mike. I just want to bring up for our viewers, because sometimes it's easier to see in a list in terms of what has been announced, and I think we have this here. But basically, it encompasses 5 aspects. New offences for preachers of hate speech, increased penalties for hate speech, there's a sentencing, an aggravated factor in sentencing, a regime to list groups promoting hatred, and it's now an offence for advocating racial supremacy. I don't know where that is going to land, though. I'm not sure where the threshold is, because I mean, Tony Burke didn't want to go into that, and when it gets down to certain phrases, of course, that's really difficult. So are you clear about where the then threshold is? I mean, when it comes to kicking people out of the country and rejecting visas as well, that's going to be really crucial, because as I understand it, the Minister has a lot of power anyway with the current laws that exist. It's just about acting on them.
Well, look, on the latter point, first, as the person who was the Secretary of the Department as we went through the Novak Djokovic issue some years ago, it came to public attention that the character provisions and the good order provisions also, there's a different aspect of the legislation under the Migration Act known as preserving the good order of Australia, is very powerful. And in fact, ministers have got extraordinary discretions under the Migration Act. And that actually came to the surface, completely different matter, of course. Mr Djokovic, it was alleged at the time and put to the court when it was tested in court that his very presence here would incite certain divisions around whether or not to get vaccinated. So the laws are actually quite strong in certain respects. I think there is a basis to clarify so that there's legislated as opposed to regulatory guidance to decision makers about thresholds around character and good order. Right. I think that's a good idea.
So it's a fit and proper person test, right? I mean, the minister... Sorry, I just got to labour on this for a moment because the minister has a lot of leeway under that fit and proper person test, right? Especially for visa holders. But is there a difference, Mike, between, you know, visitors wanting to come in and those who might be under a different visa category living here?
No. The Migration Act affords both decision makers under Section 501, so character cancellation decision makers in the Department of Home Affairs and the immigration part of Home Affairs, very powerful tool if you use it with its potency. And I'm just sitting at the desk here, so I'm just trying to remember, but I think it's Section 116 of the Migration Act, which is the Minister's discretionary power in relation to the presence of a person being contrary to the, I think from memory, the phrasing is the peace and good order of the community. Words to that effect. I'll just need to check it off air. But it came to light in the federal court's consideration of the Djokovic case. Again, not suggesting that was to do with terrorism, that was to do with anti-vaxxing and street protests and incitements to social division over anti-vaxxing. So there's very strong powers already there. Should they be extended? Look, I suspect there's probably some basis for it. I think going back to the other part of the equation, which is the speech provision, I think that there was a degree of ambiguity, or at least uncertainty in the gap between Section 18C, which is in the Racial Discrimination Act, where a person who's offended under that Act has to bring a complaint forward. Earlier this year, the Executive Council of Australian Jury actually brought a case against Wazir Madad, who was at that stage preaching at the Al Medina Centre in Bankstown, and they won the case. And so we now have case law in the federal court that says, here is what, if you like, free expression of religion constitutes, and some sermons, the sermons His Honour said were okay from that point of view, and there were 5 sermons that he knocked out and which the centre had to take down from their website and other corrective actions had to be taken on the basis that someone can't just simply get up and say, I'm going to quote here from the Quran and I'm just quoting passages that vilify Jews, but it's okay because I'm being religious. His Honour saw through that. There's a very important case that's now established the jurisprudence. It's called Wertheim versus Haddad. So maybe there's an opportunity now, maybe that could have been acted on in July, to, if you like, statutorily codify that grey zone between racial vilification, which is a civil matter under the RDA, and being prescribed as a terrorist organisation under the Criminal Code, very high threshold. Hopefully what we can now do through this legislation is address that middle gap. To your point about delay, look, other than giving officers, Christmas morning off with their families, I don't see any reason, and I regret to say this about many of my friends here in Canberra who are still in the service, I just think they should work through Christmas and get the provisions. It is complex and complicated, but there is case law that will help. I think they should get the provisions written up, the explanatory papers. The Prime Minister may choose to engage in some consultation with the Leader of the Opposition and others. I think a lot of that could start in not too long a time frame, maybe early January, and some of this could be in the Parliament, I think, quite quickly.